Welcome to the 8th edition of World Intellectual Property Forum.
Good evening and welcome to this WPIF session for biosimilars and biologics. My name is Arshad Jamil and I head the IPR department for Biocon Biologics. I am based out of Bangalore and I work in Biocon Biologics, which is the Asia's leading biosimilar organization. And Biocon, we are proud that Biocon has become the first biosimilar company from India to have launched biosimilars in the United States of America in collaboration with Mylan. So what are biosimilars? So biosimilars are the generic version of the biologics drugs. And pursuant to BPCI Act of 2009 passed in Obama era, one can file the biosimilars in the United States of America and other jurisdictions. So there is a difference between, because of the structural complexities, they are, sometimes they are MABs, they are proteins, and the regulatory setup is, I would try to differentiate between the regulatory setup of these, how they are differentiated from biosimilars. The biosimilars are differentiated from the small molecules. So small molecules are controlled by Drugs Price Competition and Patent Term Restoration Act, which is also known as Hatch-Waxman Act of 1984, wherein there are 505(b)(2) and ANDA filings are done. However, biologicals and these biosimilars are governed by BPCI Act, which is Biological Price Competition and Innovation Act of 2009. So in the ANDAs, small molecules, the applications are termed as 505(b)(2) or ANDA applications, 505J applications. However, here they are termed as, in biosimilars, they are termed as biosimilars license applications and biosimilars interchangeable license applications. There is an Orange Book listing of patents for small molecules. However, in biosimilars, there is a private exchange of the patent information pursuant to 351K of the BPCI Act, and there is a certification which is given by a generic applicant for small molecules applications or ANDA applications. However, in case of biosimilars, in the dossier, no certification is given, and only the patent exchange of the patent information is exchanged by the biosimilar applicant with the innovator company. And then there are certain provisions under 351K, which I would explain further, which goes, there is an automatic 30-month stay on generic filing in case of small molecules. However, there is no automatic 30-month stay in the case of biologicals and for biosimilars. And in the ANDAs and small molecules, Orange Book does not list process patents. So generally, as a non-OB patent, process patents can be included in the litigation by a innovator organization. However, in biosimilars, it plays around a lot of process patents. And per my experience and per our experience, Biocon's experience in the so far, which we have handled up till three biosimilars litigation. So we have seen that a lot of process patents comes into the patent exchange. So, number of patents can be unlimited. Just to give you an example, in trastuzumab, Pfizer was sued by Roche Genentech on at least 32 patents, and then the litigation was settled between Pfizer and later on, Amgen also. So at least 32 patents were sued. They were sued on. Adalimumab, similarly, the biosimilars applicants, they were sued on more than 68 patents were into the litigation, and there are more than 110 patents which came onto the adalimumab, patent exchange informations. So here, as far as the exclusivities are concerned for biosimilars and small molecules and how they are differentiated, are that there is a 5 years drug exclusivity which is granted to in the case of small molecules. However, as an NC product. However, for biologicals product, 12 years of marketing exclusivity is granted for new biological structures and for novel molecules which are approved, or we also termed them as large molecules, because the R&D and R&D investment is huge for biologics drugs, and that is why US Congress had intended that more of a exclusivity period should be given to biologics drugs so that they can meet out their expenses, and that is what the Balance Act was from the Congress. In case of, so that means that as many of you would be aware that ANDA applicant cannot file until 4 years of the NC period, and they cannot get approval till 5 years of the expiration of the exclusivity period. However, in biologics, the 12 years of exclusivity period is there. However, for filing, however, there is no bar after and filing barrier gets over after 4 years only post approval of any biological drug. However, approval could be only after 12 years. So there is a 12 years of exclusivity. In case of in case of small molecules, there is a 3 years marketing exclusivity for new indications or dosages, etc. However, in case of biologicals, there is no follow-up exclusivity because of the same biological for same biological structures. Pediatric exclusivity adds 6 months to all exclusivities and OB listed patents for small molecules, and pediatric listed in case of biologicals and biological drug also. Pediatric exclusivity adds 6 months to the 12 years of exclusivity and 6 months to the 4 years of filing restriction, and 6 months it also adds if there is a biologic 7 years orphan drug exclusivity. Now, in case of small molecules, there is a 180-day exclusivity for first filers. For biologicals, there is no such 180 days exclusivity. However, there is a 180-day notice period for commercial launch, which was settled in Amgen versus Sandoz case also, and one has to give a mandatory commercial notice for its launch prior to 180 days and post filing prior to 180 days of the intended launch. So that is those are the key differences between small molecules and large molecules and biological drugs. So contents of the 351(k) applications, as far as the contents are concerned, you have to provide analytical information, animal studies, clinical studies, and other indications of the reference products, etc., and some other additional informations about the reference product or mandatory requirements in the dossier. However, no patent information is given in the dossier as vis-a-vis of ANDA application, wherein certifications of para 1 or para 2 or para 3 or para 4 are filed in the dossier itself as a regulatory dossier. So para 1 is that when there are no patents and the patents have expired in case of small molecules, that is termed as para 1, and that certification is provided in the dossier. Para 2 is that all the patents which are listed in the Orange Book have expired. Para 3 is that the generic applicant intend to launch the product post these expiration of those patents to which para 3 is certified. Para 4 is the most complex one there, on which the litigations are brought, and one has to serve, a generic applicant has to serve the notice letter to innovator for either for non-infringement or invalidation or unenforceability of the patent, and that is where the litigation starts. And if the litigation starts, then there is an automatic 30-month stay. In case of biosimilars, once the dossier is approved, once the dossier is reviewed by the innovator, they then come up with the list of the patents, and then they share it with the biosimilar applicant, upon which then the agreement is reached that on which number of patents, post we give the notice letters of either non-infringement or invalidation or unenforceability of those patents which are given to a biosimilar applicant. Then some negotiations take place and agreement is reached upon as to what number of patents they are going for the litigation. And that is how the agreement is reached for the number of patents to be litigated. As I mentioned earlier, in case of trastuzumab, Pfizer and Amgen were sued on more than 30 patents, and then they were settled. So the litigation costs for biosimilars are huge in the United States, and that could, one could imagine and budget at least, some millions of dollars for this kind of litigation. There was a transition provision in the BPCI Act which has got over on March 23rd, 2020, and the transition period was, although that is over now, that any application which can be submitted as a 505B or 505J, if there is suitable that proteins are less than 32, then protein exception was there, and which the applications which were submitted before March 23, 2020 could be submitted as an ANDA or NDA applications. However, post March 23, 2020, this provision is no more there, and all the applications has to go through 351K route only. In case of now for the patents and FDA approvals, there is no linkage between patents and FDA approval here. And there is no stay of the FDA approval in the event of patent litigation. There is no automatic 31 stay. Patent protection and data exclusivity are separate and they run concurrently in case of this. So during the 12 years exclusivity, if there is a molecule patent and if expires earlier, then the approval would be post that exclusivity itself. And there could be number of more patents as process or MOT or formulation which could go beyond the molecule patents. So all those patents comes in the picture. However, after the 12 years or after 12 and a half years, in the event of PED granted for that molecule, one is eligible for the approval. Generally, the timeline for a biosimilar application for approval is around 1 year, and FDA gives the target action date for approval. So as I explained earlier, for the patent litigation to start on biosimilars, first step would be that biosimilar applicant share information about biosimilar product, then biosimilar applicant and reference product sponsor identify potential relevant patents, and then parties agree to the subset of the patents for immediate litigation. And 180 days before the commercial intended launch, one has to give the commercial notice of the launch. I think there are certain timelines that within 20 days we have to after the FDA notifies and that the BLA has been accepted, and one for review, the applicant has to provide to the RPS a copy of the application and information about the manufacturing process, etc. And then the patent lists and patent exchange information happens. Again, for the confidential access, one in-house lawyer and sometimes more than one in-house lawyer and outside counsel need to be given the access. That depends on the agreement of both the parties, which access need to be provided to the innovator company, and how many lawyers, in-house lawyer and outside counsel, can get an access. Then so at the same time, exchange of the patent lists, then there is a mandatory negotiation, litigation, and notification of the commercial launch. Neither party can seek declaratory judgment on the excluded patents until this 351K application has been filed and 180 days notice of commercial launch has been provided to the innovator, because that got settled in Filgrastim litigation. and the matter went up to the Supreme Court, wherein Supreme Court has held that notice of commercial launch and no declaratory judgment can be filed prior to. In Amgen versus Sandoz case, it was held that no declaratory judgments can be filed prior to the application is filed. So I think that is all I would say. I hope you all must have enjoyed this session, and thank you so much for your hearing. This is the first virtual, although we have attended, but this recorded virtual hearings. Thank you so much for your patience and hearings. If you have any questions, feel free to ask anytime. Thank you very much.